Good morning, and thank you for joining us for our next installment of our webinar series, where today we will focus on Title IX and specifically what schools' current obligations are to respond to sexual harassment complaints by students and what might change under the Department of Education's proposed regulations, which are expected to be released later this fall. For those of you who are not familiar with Franczek Radelet, we are a law firm of approximately 40 attorneys who focus on labor and employment, education, employee benefits, and immigration law. I am Amy Dickerson, a partner in our education practice group, and I am joined today by my partner Jackie Wernz, who recently returned to the firm after serving for 2 years at the Office of Civil Rights Chicago office. I am particularly excited for Jackie to join us for today's webinar to provide her insights into schools' current obligations under Title IX and what we might expect in the future. Before we get started, there are just a few housekeeping items we want to address. First, right under the presentation slides, you have the ability to type and submit questions. Please feel free to ask questions throughout the program by using this feature. Everyone logged into today's program will also receive an email that includes a link to the recording of the webinar as well as the presentation. So with that, we'll go ahead and get started. So for those of you who have been paying attention to the changes coming out of the Department of Education over the last several years, you know that we've seen a pretty big change in how the Office of Civil Rights approaches complaints filed under Title IX, and specifically regarding schools' obligations to respond to complaints of sexual harassment and sexual violence. Most recently, in September of 2017, the Department of Education withdrew the 2011 Dear Colleague letter and the April 2014 question and answer document on sexual violence, which were the main guidance documents that directed the Office of Civil Rights' approach to complaints involving sexual violence since 2014. When withdrawing those guidance documents, the Department of Education announced that it would be issuing new regulatory guidance in the near future and directed schools in the interim to follow its 2001 guidance on sexual harassment and a Q&A document that it issued in September 2017. We have since been awaiting the new regulatory guidance promised from the DOE. While as of today, such proposed regulations have yet to be issued, within the past month or so, a draft version of the proposed regulations were leaked and have been circulating among the media, social media, and among various organizations. The leaked version includes many proposed changes that are consistent with the Department's 2017 Q&A document, in addition to other proposed changes ranging from the standard that may be applied to measure the sufficiency of a school's response to complaints of sexual harassment and particular procedural requirements expected of schools when responding to complaints from students. The leaked draft has not yet been formally released, and thus they may change once proposed. But looking at those proposed regulations in the leaked draft gives us a good sense of the direction that OCR is heading and the types of changes that schools, both K-12 schools as well as colleges and universities, can expect to see in the new year under the new regulations. So in light of this, we thought it was a good time to review what the current obligations are under Title IX, discuss what might change if the leaked draft regulations are published, and where to go from here. So I'll turn it over now to Jackie to take us through what sort of our current obligations are under Title IX, and then as we talk about those, we'll also talk about what might change under the proposed regs.
Hi everyone, this is Jackie Wernz. It's great to be with you today. So as Amy mentioned, there are a number of responsibilities under Title IX of which you should be aware. And from looking at who's in attendance today, I'm assuming that most of you are aware of these various responsibilities. The main one that we're going to be talking about today is the fourth requirement that you see here, which relates to responding to complaints of sex discrimination and specifically, as Amy mentioned, sexual harassment and assault. And that's because that's where the focus of the recent changes have been. Now, one thing that we did want to point out before we go there is that there are enduring responsibilities with respect to your Title IX coordinator. As Amy mentioned, when the Trump administration rescinded those guidance documents and issued new guidance documents in September 2017, it did leave in place the April 2015 guidance regarding Title IX coordinators. And if you haven't reviewed that document lately, I would recommend you do so to refresh yourself on the responsibilities there. And always feel free to reach out to one of us if you'd like us to direct you to a copy. But generally, you're required to have a Title IX coordinator who's well known to your school community, available to students and parents and other community members as needed, and knowledgeable and well-trained on the school's Title IX obligations and policies and procedures. You would be amazed at how many schools fail to provide even the most limited amount of information about their Title IX coordinator to the public that's required by the 2001 guidance, which requires notice about name, office address, and telephone number. We usually advise that that be included in policies and student-parent handbooks and on the school's website. But again, in my experience at OCR, you would really be shocked that sometimes even that basic information is not consistent or is not included throughout all of those different documents. Moreover, one thing that we looked really closely at OCR was training. And this is especially true if your Title IX coordinator and investigators don't get a lot of investigations or a lot of firsthand experience on doing these things. What you want is to have some dynamic, engaging training where Title IX staff are working with real-world examples and applying your policies and procedures. And a lot of times the canned trainings that you might get at a conference or something of that sort isn't going to give someone the level of experience that they're going to need to actually handle a tricky complaint when one of them arises. Amy and I both regularly provide this type of training for school staff, and we'd be happy to provide you more information about what you might want to look for in that type of training going forward.
Jackie, I'll note there that, I know that most colleges and universities now, when they identify their Title IX coordinator, that is the name of the person that's in that role as the Title IX coordinator. Whereas for a lot of our school districts, at least within Illinois, oftentimes under their policies, they may refer to their Title IX coordinator as a non-discrimination coordinator or complaint managers as their deputy Title IX coordinators. And so I'll note that under the draft regulations, those, at least the leaked version, would expressly require that schools' Title IX coordinators be specifically called Title IX coordinators. So this is something for particularly our school districts who are listening to pay attention to if those a version of the leaked regs are the ones that actually become proposed, that might be a change that would need to be made in policies and procedures.
That's a great point, Amy. So I mentioned the scope of Title IX and all of the things that we won't be talking about today, but we wanted to give you just a sense here of the scope of how many different types of issues are really covered under Title IX and that are your responsibility. There are the most frequent issue other than sex harassment and violence that came up during my time at OCR was athletics under Title IX. Where complainants argued that schools failed to provide male and female students equal opportunities and benefits in school athletics. Those can be really tricky cases, and it's important to take steps before a complaint to prevent a complaint before one arises, because it's an area where I literally didn't have a case where there wasn't a problem, because it's really tricky to keep in compliance unless you're auditing your program and considering as you're going along whether or not you are complying with the requirements there. Retaliation is also a big one for OCR, and I just wanted to remind you that it doesn't matter for purposes of retaliation if the underlying complaint is actually valid. If a person makes a good faith sex discrimination complaint and suffers an adverse action in response, they can raise a retaliation claim, no matter how meritless the underlying complaint. And for those of you from universities who are on the call and colleges, remember that your professors can be responsible for retaliation. It's natural for someone who's been alleged to have sexually harassed someone else to not want to work with that person going forward, but especially in the university context where professors take such an important role in guiding students, whether it's through being advisors or only teaching specific classes, if they take a position that they can't work with that person, it can be retaliation. So it's really important to make sure that when you're training staff on retaliation that you're being very clear about what can actually constitute retaliation.
Now, the draft proposed regs that we're going to be talking about today, we're talking about the focus as to the potential changes for schools' responses to sexual harassment. But we did want to just note that there's been some recent discussion and articles regarding a possible change in the definition of gender that the Department of Education and potentially other departments are looking at that could affect how the Department of Education approaches issues related to transgender students. Specifically, these articles have talked about looking at defining gender as a person's status as male or female based on immutable biological traits identifiably by or before birth. Further proposing that the sex listed on a person's birth certificate as originally issued should constitute definitive proof of a person's sex unless rebutted by reliable genetic evidence. So as we monitor the proposed regulation status and see what those actual proposed regs look like when they come out and are actually officially released, we'll be specifically looking to see if a definition like that is going to be added or included in the proposed regs or come out of some other department's regulatory guidance.
Okay, so now let's talk about sexual harassment and violence and what's required and potentially in store under the leaked regulations. So Title IX holds schools responsible for sexual harassment and violence of which it knows or should have known. This means that if a responsible employee knew or in the exercise of reasonable care should have known about the conduct, the institution will be deemed to have notice of the conduct. Now, should have known includes all types of conduct, conduct that's widespread, if it's well known among your school community, or if it could have been found based on a reasonable inquiry after receiving actual notice of similar incidents. And also, remember that under the current guidance from OCR, that if an employee is the harasser and they commit the harassment while they are doing their employment duties, that the school is deemed to have known that the conduct occurred.
So under the draft regulations, not only is there a proposed definition for sexual harassment, but there's also an actual knowledge standard that would be applied. So actual knowledge as defined by the leaked draft regulations would mean notice of sexual harassment or allegations of sexual harassment to an official of the recipient who has authority to institute corrective measures on behalf of the recipient. And would note that the mere ability or obligation to report sexual harassment does not make an official someone who has the authority to institute corrective measures. This also would not include, unlike what Jackie noted is currently the requirement, this would not include the actual respondent of an institution. So this then would affect who is considered to be a responsible employee as referenced here. So Jackie, under OCR's current approach, in light of the withdrawal of the 2011 and 2014 guidance, does OCR still construe who a responsible employee is quite broadly?
Yes, the definition is quite broad. So a responsible employee is defined under the 2001 guidance as any employee with the authority to take action to redress sexual misconduct or who has the duty to report misconduct by students or employees to appropriate school officials, or who a student could reasonably believe has such authority or responsibility. So as Amy mentioned, this definition is being proposed to change, but right now what's important to remember is that that broad final prong about who a student could reasonably believe has the authority or responsibility, that's something where you're really going to have a risk that a lot of your employees are going to be pulled under this realm, especially in the K-12 context. So as it exists right now, this definition is quite large. And I would say this is one of the areas where I saw schools getting tripped up in complaints very frequently. So a student would notify a teacher or a dean of students that conduct had occurred, and that person wouldn't have had the training to correctly identify the conduct as sexual harassment or some other conduct falling under Title IX. So then the school would use the wrong policy and the wrong process to process the complaint and wouldn't comply with the very stringent requirements typically under the Title IX policies. So it's very important. This was something that's been highlighted in the 2001 guidance for a long time, but to train employees on practical information about how to identify harassment and to whom they should report that conduct. And then also in the higher ed context, one thing that I saw a lot of was over-reliance on confidential reporting contacts for students. So I guess one way to think of it is if your school hasn't had an actual Title IX complaint in a number of years, and you look at your data from your confidential reporting contacts at the school, and you see that there's a significant amount of reporting happening there, that may be something that you want to look into a little bit further because it is going to look strange to OCR if they come in and it appears that students are being pushed toward confidential reporting resources. Now, this is a tricky issue because I think most people, especially in higher education, would say that students need to be given the option to report confidentially, and that is something that I think OCR completely agrees with. But again, it's just a fine balance between making sure that you're not encouraging that to happen more frequently than might be what students would otherwise want or benefit from.
Those are great points, Jackie. And so this is also an area then where we might see a change under new regulations. So under the leaked draft regulations, as stated earlier, who a responsible employee is would be construed more narrowly, as the draft regs say that the mere ability or obligation to report sexual harassment does not qualify an employee to institute corrective measures on behalf of the school. So even if a professor or administrator may be directed under the school's policies to report sexual harassment that they hear about or observe to the Title IX coordinator, their knowledge alone of the sexual harassment may not be sufficient under the draft proposed regulation language to put the school on notice such that the school would be deemed to have actual knowledge that would trigger their obligations to respond. Of course, once they do notify the Title IX coordinator, then the institution would be considered to have that actual knowledge. So for colleges and universities, as well as K-12 schools, Title IX coordinators would always be considered to be officials with the requisite authority under the draft proposed regulatory language. In the K-12 context, the draft proposed regulations would specify that for primary and secondary schools, teachers are also officials with authority to institute corrective measures. For higher education institutions, however, it appears that there may not be such express proposed revisions, and thus it's possible that professors and other administrators who do not have the authority to institute corrective measures may not be considered responsible employees under Title IX, even if such individuals are still directed to report sexual harassment to the Title IX coordinator. So as Jackie and I were discussing this particular provision earlier, we were both noting that it's really going to matter how those actual proposed regs, what that language actually looks like in order for schools to best determine how they're going to identify who is responsible for reporting internally as we kind of balance how we would envision OCR interpreting this requirement.
Thanks, Amy. So once you've become aware that there is a complaint, what are the responsibilities under Title IX? So as it's currently interpreted by OCR, Title IX requires that once a school has notice of possible sexual harassment or violence of students, it must take immediate and appropriate steps to investigate or otherwise determine what occurred and take prompt and effective steps reasonably calculated to end the harassment, eliminate any hostile environment created, and prevent harassment from occurring again. One thing that I saw parents complain about a lot at OCR is that the school didn't notify them that their Title IX, that they had Title IX rights or what their Title IX rights were at the time that they reported the conduct to the school. Now, providing notice of the procedures in your policy and student handbooks and other documents is sufficient to appease OCR, but you may want to consider providing notice of the procedures in writing at the time of the complaint. Another common issue is what information can be shared with the complaining student at the end of the investigation. There's a little bit of a difference here between what higher education entities are required to provide under the Clery Act, which is written notice contemporaneous at the end of the investigation. But for our K-12 schools, really that all the 2001 guidance requires is that notice be provided. However, we would recommend that notice always be provided in writing to both parties. And also remember that the reporting student has to be told certain facts about the investigation. So they need to be told whether their allegations have been substantiated. They need to be told about any discipline that's been undertaken, if it impacts them personally. And OCR is not going to be persuaded by arguments that student privacy considerations prevent sharing that information with the alleged victim. I saw that argument a lot, and it was never a successful one.
Now, under the draft regulations, the obligation to act and follow procedures is triggered by a formal complaint filing by either the victim or institution, as opposed to just knowledge of a report of sexual harassment. So this would be a change in schools' procedures, or at least a potential change in schools' procedures based on what OCR would see as requiring and what would trigger a school's obligation to respond. And the draft proposed regs define a formal complaint as an actual document that's signed by the complainant or the Title IX coordinator alleging sexual harassment against a respondent and requesting the initiation of the recipient's grievance procedures. So on the one hand, this would result then in the school's grievance procedures only being triggered once the student chooses to formally file a complaint if the school's policies are consistent with that. But the draft proposed regulations do also state that when a recipient has actual knowledge of reports by multiple complaints of conduct by the same respondent that could constitute sexual harassment, that in that instance the Title IX coordinator must file a formal complaint even if the victim does not request to do so. So that's not too dissimilar to the current obligation under the 2001 guidance to consider when a school might have an obligation to investigate a complaint even if an alleged victim wishes to remain anonymous or have their complaint remain confidential. But the draft regulations would propose that that be an express requirement. Now, Jackie just mentioned before the standard for a response under the current Title IX guidelines. Under the draft regulations, an institution with actual knowledge of sexual harassment would be required to respond in a manner that is not deliberately indifferent. So deliberate indifference would be defined as a response that is clearly unreasonable in light of the known circumstances. Now, this is also the current standard that is applied for federal court cases where a school is accused of failing to sufficiently respond under Title IX. Thus, what would change if these rules were actually proposed and adopted is that OCR would now apply the same standard as well when reviewing complaints filed by students, as opposed to applying a higher standard requiring schools to take steps that are reasonably calculated to stop the harassment, prevent its recurrence, and remedy its effects. Under the draft regulations, there would also be a safe harbor provision that would exist for educational institutions where an institution, if it followed its grievance procedures in response to a complaint, the institution will have been found and would not have found to have been deemed deliberately indifferent. So in other words, so long as they can show they followed their procedures, they would not be deemed to have acted deliberately indifferent toward the student's report.
We wanted to drill down a little bit on investigation. So what should your investigation look like once a Title IX complaint is received? We've listed some key points here to consider, but I wanted to highlight specifically the need to provide written notice to the alleged perpetrator prior to an interview. There's been a major shift under the current administration toward concerns for the rights of alleged perpetrators or responding students. And a common concern that we hear is that the responding student didn't feel that they had sufficient knowledge prior to an interview or a hearing, whatever the process is, to really defend themselves. And this includes the names of the reporting students or the alleged victims. Again, something I saw frequently, especially with K-12 schools, was schools relying on concerns about student privacy as a defense to identifying the victim. But that's, again, going to be a difficult argument to make with OCR. And that's why it's so important to explain limitations on confidentiality to reporting students during the intake process. Also, the last point here on the slide, you simply cannot wait for the outcome of a criminal investigation. Some deference to allow the police to do initial fact-checking may be okay, but you've got to conduct your own investigation. And this is a fine line to walk, so we really encourage you to make use of your Franczek Radelet attorney for Title IX complaints, particularly those involving criminal charges.
Under the draft regulations, similarly to what the best practice currently is, once there's a receipt of a formal complaint, the institution must provide written notice to all parties of the recipient's grievance procedures and of the allegations. And the notice must include sufficient details, such as the identities of the parties involved, the specific section of the recipient's policy allegedly violated, to provide sufficient time for all parties to prepare responses before any initial interviews.
So on this slide, we have some of the due process requirements that we would want to see in a current Title IX investigation. One thing to note is that with respect to the fourth bullet here, which relates to the requirement that policies and procedures identify the possible sanctions and standard of evidence to be used in Title IX investigations, the September 2017 Q&A removed the Obama-era requirement that the preponderance of the evidence standard be the one that schools use in these investigations. So the new guidance does allow schools to choose between preponderance of the evidence and clear and convincing evidence. The standard of proof used does need to be consistent with that that's used in other student conduct cases. And just so that you know, clear and convincing proof means that the evidence presented by a party during the hearing or the investigation must be highly and substantially more probable to be true than not. And whoever the trier of fact is must have a firm belief or conviction in its factuality. So this is a lot more than that 50% and a feather that we talk about with respect to the preponderance of evidence standard.
So some specific procedural steps that are proposed in the draft regs that we see, while some colleges and universities may have these, others may not, and likely K-12 schools may not. And some of these include showing a draft of the investigative report to all parties before finalizing the report, giving the parties the opportunity to pose all relevant questions to each other. So the regs go into detail about the explanation to the draft regs go into detail about how if a college or university has a hearing model, cross-examination must be allowed, while if it does not have a hearing model, parties must have an opportunity to pose questions to the investigator to ask of the other party. In the K-12 context, however, the draft regulations at least would not require cross-examination. Other procedural steps that we see that may change here are in written finding letters. The information that's given to each party must be the same, including the sanctions and remedies that are issued, which may be a change for some of our K-12 schools. Both parties are allowed to have a representative, which may be an attorney. And the draft regulations do also allow for the immediate removal of a student on an emergency basis if certain factors are present. Specifically, if the school undertakes an individualized safety and risk analysis, determines that an immediate threat to the health or safety of students or employees justifies removal, and provides the respondent with notice and an opportunity to challenge the decision immediately following the removal. So this does seem like an attempt to address concerns by K-12 institutions where there may be certain instances that require a school to immediately suspend a student, which seem to have been potentially thwarted by this requirement that you have to give written notice to the respondent before actually interviewing them.
So you've completed a perfect investigation and found that a violation of Title IX has occurred. So what's next? It's time to respond. And these are some examples of some of the responses that you might consider. One thing to note here is that even if you can't discipline the perpetrator, so for instance, maybe the conduct occurred off campus and you don't feel that you have enough of a nexus to discipline the perpetrator, you may still be required to respond in other ways. And if you have a situation where there appears to be a widespread tendency towards sex-based misconduct within your school community, you must consider community-wide responses, such as in-classroom or school-wide trainings for students and other remedies beyond the reporting and responding students.
Okay, so then other changes that we will see potentially under the draft regulations, we've already talked about how there's the potential for the change in the standard of evidence to change and how that has to be consistent with your code of conduct standard of evidence. There's also additional changes that you may have seen if you've been following these with regard to the religious exemption and clarifying that educational institutions may but are not required to seek assurance of its religious exemption by submitting a written request for such an assurance to the Assistant Secretary. Now, in explaining these regulations, the DOE states that this is not different from the current practice. It just now brings the regulations in line with the current practice. But there certainly has been a lot of discussion and potential controversy over that potential change. Other things that they note are just the proposed regs would make it clear that Title IX would preempt FERPA to the extent there's a conflict. It specifically identifies informal resolution as being an option for schools, including mediation for sexual violence cases. And it also discusses retaliation as being a measure that would be protected. And the proposed rules also require that recipients ensure that Title IX coordinators, investigators, and adjudicators receive training on the definition of sexual harassment, how to conduct an investigation and grievance process, including hearings, that protect the safety of students and ensure due process for all parties and promote accountability. Now, in practice, this is something that OCR has always strongly encouraged, as have we, but it is expressly required for colleges and universities and other federal and state laws. But this would now be expressly and clearly required under Title IX for K-12 schools. There's additional provisions that we see in the draft regs that would streamline the requirements for where a non-discrimination statement needs to be published, and additional procedural steps that we may not have discussed in specifics today. So, as far as takeaways as we wrap up here, one thing we note is that, a few things. One, the regulations do include very specific grievance procedures, or I should say the draft proposed regs include very specific grievance procedures that would have to be followed. So for colleges and universities, the specificity of those procedures may not change significantly from what is required under state law and the Clery Act, but certainly colleges and universities are going to have to examine how certain aspects would need to be changed. But for K-12 schools, at least those in Illinois, that just the fact of having such specificity be required under Title IX would be a significant change in their procedures, and their procedures would have to conform to that. So if the draft proposed regs are adopted, they would no doubt require some policy and procedural changes for all schools. For higher ed institutions, it would require examining the proposed regulations in comparison with current requirements imposed by other federal and state laws to see what changes would actually be required. For K-12 institutions, the grievance procedures would be required to conform to those detailed procedures that are set forth in whatever regs are ultimately adopted. They'd require notices that would likely have to be developed, specific written notices that would maybe be required under the procedures, and all schools would clearly have to institute the particular required training among other policy and procedural changes. So again, these are all still draft proposed regulations. We will be monitoring when any actual proposed regulations are issued, and we will send updates through our FR alerts when they are. So if you're not currently on our mailing list to receive our FR alerts, there will be instructions on how to sign up to receive them, and when you get the recording of today's webinar. Once the proposed regulations are issued, we will have a better idea of what particular types of changes may be required of different schools and what steps schools may want to take to prepare. Once the proposed regs are issued, there will also be an opportunity for public comment before they are finalized. And additional input and possible revisions may be made to the proposed regulations before they are finalized. And so we do note that the draft regs identify particular questions that they are seeking feedback on, such as whether the training requirements should be more specific and whether any requirements should be further differentiated between K-12 obligations and higher education institutions. Thus, these may be opportunities that all schools wish to take advantage of or coordinate with other local, state, or national groups to submit comments during this period. Either way, we will keep you updated as the process continues, and once we will have a better idea of what will be included in the final regulations. So to close, we want to thank you for joining us this morning, and we want you to save the date. Our next Education Monthly webinar will be on November 27th. We'll be talking about the topic of property tax FAQs, where we'll take a quick look at commonly asked questions and key facts that all administrators and board members need to know about the single largest source of education funding in Illinois. Thank you again for joining us, and have a great rest of your day.